All right. Hope everybody can hear me. Let me know if you can't. I have started the recording now for this, our second presentation in this 2023 Student Scholar Series. I'm A.G. Harmon of the Columbus School of Law here at the Catholic University of America. And on behalf of the faculty, let me thank you for zooming in to this second in our series. Please stay on mute until the presentation and response are over, and then I'll open up the floor to questions, which you'll signal with just your raise hand feature. So I'll know to call on you then. This series was instituted 14 years ago now in order to recognize notable legal scholarship produced by members of the student body during the previous academic year and to foster the skills associated with presenting and defending that scholarship in a professional conference style setting. Today's presentation will be made by third-year student Mark Tocchio. Before I introduce Mark, a few words about the respondent to his presentation, Mark Bourbeau. Mr. Bourbeau's practice is concentrated in the representation of public and private clients in a variety of civil litigation matters, development issues, and consultation with specific emphasis on the areas of real estate, eminent domain, environmental law, governmental relations, and business litigation. Prior to entering private practice in 1991 at DTM there in Massachusetts, Mr. Bourbeau was the senior trial attorney in the eminent domain division of the Office of the Massachusetts Attorney General. He has taught numerous real estate and law-related courses at Northeastern University's University College and Newbury College. He also has served as an advisor in Harvard Law School's trial advocacy workshops and as a judge in its Ames mid-court competitions. We're honored to have him here today. Thank you. Now I'll introduce our student scholar, Mark Tocchio. Mark graduated here at Catholic University in 2020. He started law school in the fall of 2020. He has worked as a legal intern for the Commonwealth of Massachusetts, the Securities and Exchange Commission, as at a private law firm in Massachusetts as well. During that time, he worked with litigation attorneys on eminent domain cases, which piqued his interest in the topic upon which he will speak today. His interest in constitutional law and in the controversial holding in Kelo versus City of New London contributed to his interest in that area. After graduation and the bar exam, he will be working as an associate at Koppelman and Page, as it was known. He saw me, it's KP Law now, as that's the fashion. A law firm of approximately 50 attorneys there in Boston, specializing in municipal law. And they represent, I think what he is telling me is a third of the cities and towns in the Commonwealth of Massachusetts. So he'll have a lot to do there. I'm going to now turn the floor over to Mark Tocchio to present his work entitled Eychaner. I hope I'm saying that right, Eychaner versus City of Chicago, Repercussions after the Supreme Court refuses to take up a Takings Clause Reconsideration. Mark.
Let me just share my screen. Oh, I'm a little ahead here. Is that coming across all right?
Looks good.
All right, good afternoon, everybody. Thank you, Professor Harmon, for the introduction. And thank you to Mr. Bourbeau for attending today. He's been a great resource to me throughout law school and especially on eminent domain topics. He's certainly an expert. Some very interesting experience on the topic. So today I will be discussing the Takings Clause as it was decided, a significant case, the Kelo case in Connecticut, and some of the consequences that have come from that decision. Since then, economic redevelopment by private parties has been a sufficient justification for eminent domain takings. And we have seen that occur throughout the country in many cities. And there have even been certain evolutions of that, such as future blight and takings that involve presently unblighted land for the benefit of the public, as the government will argue. Just a little bit of background on eminent domain. So it appears in the Fifth Amendment's taking clause as stated, nor shall private property be taken for public use without just compensation. Those two limits being that the taking has to be for public use or public purpose, as is seen in many statutes now, and that the private property owner be compensated justly. You see two generally types of lawsuits to eminent domain, where property owners will either sue and challenge the validity of the taking, arguing that it's not for public use, or you will see a challenge to the compensation against the government taking authority. Public use has generally been used, eminent domain has generally been used across the country for different uses such as airports, bridges. You see more locally many easements for things such as power lines, other uses in the municipal field. One limit that has been contentious, and you'll see through the Kelo case and through the Eychaner case, is this balance between the principal benefit and the incidental benefits, because many takings involve private partners, such as a bridge company may have to be brought in to do that, and that'll be a private company. More close to where we are located in DC, I will quickly say, in this case was very important in Kelo. Berman v. Parker involved the taking of a large part of Washington, DC to redevelop it and to lead to a lot of the different structures that we see today. That was a taking for blighted property, blighted area, to turn it into a more aesthetic area. And a store owner challenged. The store owner had a unblighted property. It was a successful business, and the Supreme Court held that as part of a large comprehensive plan, private property could be taken even if unblighted, because the legislature made a determination. And that is something that we'll see reoccur in Kelo, this deference to legislatures in making decisions and how to use their eminent domain power for redevelopment. The Kelo case, which was decided in 2005, and as many of you will know, is a controversial case, involved the redevelopment of New London, Connecticut. In the 90s, New London went through a period of economic distress. They were losing people, they were losing their tax base, and they made a decision to take a large portion of the waterfront district known as Fort Trumbull and to institute a redevelopment plan. Many of the properties that they needed to successfully carry out this plan were willingly sold by property owners nearby, but there were about 9 holdout property owners that were unwilling. Consequently, the government entered into condemnation proceedings and took these private properties, including Suzanne Kelo, challenged the validity of the taking, arguing that it was not for public use and that their property was presently unblighted. There was no justification to take property just to bring in a better, prettier use for the city. That decision was ultimately, or that case was ultimately appealed to the Supreme Court, and in a 5-4 decision, the U.S. Supreme Court upheld those takings. They reasoned that the New London's redevelopment plan had sufficiently met the public use requirement, and although it was transferred to a private party, they held that the comprehensive nature of the plan, the legislative intent, and the manner in which it was adopted showed that it was a public use and it was not intended to benefit private individuals. Many critics have came out and argued that a big part of this redevelopment was to entice Pfizer to open a large research facility nearby, to bring in restaurants, hotels, and these were all things that were better for the area, but not something that justified the taking of private property owners. These private property owners had been there for a long period of time, some of them generations, and that was not constitutional. That's what critics will argue, and that is also what I argue. The court held also that there's a large deference to be given to legislatures, and that's again what we saw in the Berman case. It was reasserted, and this holding effectively expanded the definition of public use for eminent domain to be extremely broad. And as the dissents argued, it it really just frustrates the purpose of the public use limitation and blurs the line between private and public uses. As I just mentioned, there were two visceral dissents by Justice Thomas and the principal dissent by Justice Eychaner. They both had a common concern that giving this power to local governments as a justification for eminent domain was really something that was very prone to abuse, and that people with political connections and deep pockets, such as corporate development firms, would be able to game the system and entice cities to take land and transfer it to them to be developed, which in turn under the Kelo holding would be permissible. Further, Justice Thomas, which you'll see in the Eychaner, he does dissent from the denial of the grant cert. He argues that there's a common law background and the text of the Constitution does not authorize a government to take land transferred to a private party. So just getting into mostly the crux of my paper, which has to do with the Eychaner case in Chicago, I'll give just a little bit of overview. This has to do with a plot of land in Chicago that is down the road from a large chocolate factory. This is one of the largest chocolate ingredient manufacturers in North America. And they, in the early 2000s, the chocolate factory had opposition to a zoning change that the city of Chicago wanted to put forward. They argued that they had some issues with nearby residential neighbors and that they wanted to take a nearby vacant plot of land to develop it and make it part of their campus. The city and the chocolate company went back and forth, and they eventually, Blommer eventually, I guess you could say under threat, said that if we're not able to have this buffer between the residential area and our operations, we will strongly consider leaving. This scared the city. It's an area that they want to have continue to be a manufacturing district, and this chocolate factory creates jobs and tax revenue. So the city and Blommer eventually passed a River North tax finance redevelopment plan, and this is known as a TIF, a tax increment financing plan, which eventually takes public investment and turns it into private and public development. So in the case, as I'm getting to, the city condemned the nearby tract of land, which belongs to Fred Eychaner. They cited under the statute, the tax redevelopment plan, that the private property was not currently blighted, but it fell under the definition of a conservation area. Conservation areas are really just, if they meet criteria under the statute, they're at risk of in the future becoming blighted or becoming slum. So as you'll see in the next few slides, some of these criteria have to do with extended vacancies, dropping property values nearby, and code violations. So what the city did is they took Eychaner's land and they transferred it to Blommer as part of their development of their campus, just to really appease what they wanted. And under the justification, as I just mentioned, they used future blight. And that was how they justified that it was for a public use. Fred Eychaner had several challenges to the taking. The first being that the property was not presently blighted, and there's no recognized precedent that allows property to be taken for a speculative future blight. Further, that the city intended to transfer the property to a private party for its use, its sole use, and there was no law that would control what the private party, how they had to use the land. So in terms of what Blommer could do with the land, that was up to their discretion, and that really shows that this was not intended to be a public benefit. Further, the public will not reap the benefit of the use. They don't have the ability to use this property, and it solely was going to Blommer for the development of its property. Having a little trouble advancing here. All right, there we go. So this gets back to, in Kelo, the future looking justification behind the taking. So in Kelo, they took this land and the court said they had a comprehensive plan. This wasn't a private benefit. They were thinking about what would happen for the public, for the area to heal this economic distress. And what is interesting about the Kelo case and why it gets a lot of heat is that land, there's no waterfront district in New London that really came to fruition from what their development plan included. The land, as you can see in this picture here, I hope you can all see that. That's what it looks like years later. It's vacant. There was a lot of cleanup from a recent hurricane that really kind of spilled over there, and it's full of, as Professor Selecki and I discussed when we wrote this paper, feral cats. So there's a lot of abandonment going on there. I also wanted to really highlight how some of the flawed factors that they used in the Kelo holding for their reasoning kind of rear its head in the Eychaner case. And that may be that the comprehensive plan does not pan out. As I just mentioned, there's no controlling law on what Blommer Chocolate has to do with that property. And it is for their redevelopment and their use and their benefit. Further, as the justices cited in their denial to hear cert on Eychaner, the chocolate company was purchased a few years ago by a Japanese corporation for, I think, around $800 million. So it really goes to show that they did reap a private profit from this. Not that there is a direct correlation, but it is important to note that. And the Supreme Court justices felt that that was important to include in a footnote in that. Further, the comprehensive planning in Kelo, we saw that it didn't pan out. And I believe that in Eychaner, the comprehensive planning really goes back to the conversations between Blommer and the city early on when they were discussing the opposition to the zoning change, and that many of these development projects, you cannot just look to the comprehensive planning alone. If you have, a process that comprehensive planning is the only requirement to meet, or one of the only requirements to meet the public use justification, this can be easily gamed, and you'll have politically connected people that go through the process with the intent of meeting the public use requirement through that. As I mentioned in the Eychaner case, future blight was the justification for taking that property. I argue that it is an extremely unreasonable standard, and the factors that tend to have to be met to really meet the future speculative blight determination, they are kind of self-fulfilling in a way, and they overlap, such as you'll see in the Eychaner statute, the deterioration, code violations, excessive vacancy, lack of community planning, and lagging property values. Once these studies, oftentimes there are private firms that come in and they do an economic study on the area. Once that is initiated, you'll see lagging property values. Once that's out there, there's less of an incentive to invest in the neighborhood. And once there's a determination that the area is under a conservation title, then it doesn't really incentivize the investment of the property. Further, excessive vacancies. Eychaner's property was vacant. It was a large city block, and under eminent domain law, the just compensation is the highest and best use of a property. So if you're looking at his vacant property, it had a very high highest and best use, as it was right in the River North neighborhood. And further, this review process can be subjectively applied. These private firms that come in and do these studies oftentimes are working in connection with local planning authorities, and that is something that is at risk of abuse. And as I mentioned, there's a self-fulfilling nature to these factors. And further, it disincentivizes poor residents that have been in these areas to continue to invest in their community. Finally, I believe Eychaner was the proper facts to reconsider the mistake that was made in Kelo. There are remaining limits that are unclear, and those have to be heard by the Supreme Court so that there's some limit to what the public use clause can be extended to. The appellate court of Illinois in the Eychaner case reasoned that it was too difficult to discern whether or not there was a sham taking as a pretextual taking for a private party or a public use. This ambiguity between the two, that courts don't have a bright line rule to apply, is problematic and needs to be cleared up. Eliminating blight is currently a recognized valid use of the eminent domain power, but the future blight and speculative blight justification is unreasonable and does not have any real limits at the present, and is extreme risk for private property owners, especially in cities where you see rampant development and gentrification. It's really problematic and needs to be addressed by the court. Professor Harmon, that is that. Thank you very much.
Thank you, Mark, very much. And I'll turn it over to Mr. Bourbeau, if you would conduct the response with Mark for about 10 minutes, back and forth between the two of you.
Excellent. Well, all right, I'll start with questions, but let me first explain that the questions that I've chosen to ask have a little bit of a setup so that we can put the question and the answer in the proper context. So let me start with this one. Mark, in 1795, Justice Patterson, who had been a member of the Constitutional Convention in the case of Van Horn's lessee versus Durant's, which is 2 U.S. 304, described eminent domain as the despotic but necessary power of government. As such, he stated, the presumption is that the legislature will not call it into exercise except in urgent cases or cases of the first necessity. And then further, he says, it was difficult to form a case in which the necessity of a state can be of such a nature as to authorize or excuse the seizing of landed property belonging to one citizen, giving it to another citizen. This was because, he said, it was immaterial to the state who owned land, but that the ownership must be protected. So it starts with that. Now, the public use and just compensation requirements are both placed in the Fifth Amendment, which was ratified in 1791. Do you see any significance to this, Mark, and Justice Patterson's statement shortly after? And what might it indicate in terms of creating a unifying theme or set of factors as to what is constitutionally acceptable as a public use?
Thank you for the question. I would say that the Fifth Amendment as a whole really aims to protect the government from unfairly punishing disfavored people and to really repair wrongs that were seen before the Constitution was ratified. And I think that taking of property and protecting private property is a very important limit that they had in mind, and to require that it be used for public use and that just compensation be included. I think from Justice Patterson's statement, just on its surface, it really indicates that there was a strong intent to limit the government's ability to take property. And as you said, it serves as an important warning that the power is one that could be abused. In terms of set of factors, I think one thing is clear, that there should be a strong presumption against taking property from one citizen and giving it to another citizen. And as his comments indicated, absent an urgent necessity, it should not be something that's permissible. And I think over time, it's really interesting that those comments are from 1791, and I think they still rear their head today. And that's just something that I think the factors have been lagging in terms of courts establishing bright line tests for what is a valid public use in terms of taking property for redevelopment through a transfer to a private party. So I think this has been a topic that has been around and highly contested, and there is a real need for a universal set of factors or some bright line tests that can help clear those blurred lines.
All right, well, further toward that point, let's talk for a minute about Kelo itself. Justice Kennedy, in his concurrence, stated that courts should strike down takings that by a clear showing are intended to favor a particular private party with only incidental or pretextual public benefits. In one way or another, the rest of the court seemed to agree with that basic principle that incidental public benefits weren't enough. But none of the several opinions, including the dissents, attempted to define where the line fell between merely incidental and sufficient public benefits to justify transferring from one party to the other. As a result, it would seem that lower courts appear to be settling the bar at different places, making the determination a matter of circumstance and geography. Some focus on one degree to which there is a integrated development plan, others examine the intentions of the taking authority, some look to the weighing of public and private benefits. Do you think Eychaner confuses the matter even further? And what considerations can you suggest to help determine when the inflection point occurs, where the purpose of a taking changes from permissible primary public, incidental private benefit to the impermissible reverse of primary private benefit with only incidental public benefit?
To address your question about Eychaner, I do think that confuses the question more. And in Eychaner's arguments, he cited a case where the court looked at the motivation behind the taking. They said that it was that they didn't even perform economic studies, and that they were kind of just throwing out these terms without actually backing it up with good faith planning and good faith effort to ensure a public benefit. I also think that because there's no bright line test, really, there are factors that Justice Kennedy and his concurrence in Kelo stressed would be important, and that really goes to the good faith behind the taking and the planning. At what point they identified private parties that could have an incidental benefit. And I think further, it's important to look at the pre-taking conduct by the parties. If there are other ways to achieve the means that they want, or if there are other means to achieve the end of the public use or benefit that they want, if those have been pursued, if there's evidence of the parties to really to show that they were working in a course to achieve that public benefit, I think that would be a factor that points to what the motivation behind the taking is, and may clear up the, I guess you could kind of say, the balance between the primary or the principal benefit and the incidental benefits that happen in a lot of these cases.
Just a little follow-up on that question. What about the instances in which the taking is requested essentially by the party that's going to get it in the end, like Eychaner or like some of the other cases? Do you think that factor counts or should be taken into consideration in terms of whether or not the purpose is primarily public or primarily to benefit the private party?
I think that is absolutely an important factor. And I think that points to it being a private benefit, and or primarily a private benefit. In the Eychaner case, as you just mentioned, they were really resolving kind of a disagreement between instituting that zoning change. And that is evidence that the end really was to give them property for them to develop, and to this, on the city's behalf, to adopt the zoning change, which was what they wanted to happen.
Okay. Now, there have been two other interesting recent rejected certiorari cases prior to Eychaner that attempted to get the court to revisit Kelo and set limits on constitutionally valid public use, where the taken property was to be transferred to a private party. One is Violet Court Dock versus St. Bernard Port, Harbor Internal District, where the taking transferred a profitable port facility from one private company. It was owned by a private company. They took it and then they leased it to another private company, which promised to share the revenues with the public body. So essentially, they took it and then gave it to another private company simply because that company would share revenues with them. The other case was Punteni versus Iowa Utilities Board, where the Iowa Utilities Board authorized the use of eminent domain to build the Dakota Access Pipeline across Iowa, but which would not pick up or drop off any oil within Iowa's boundaries, thereby offering no direct benefit to any of Iowa's citizens. Do you think these rejected cases, now viewed in light of Eychaner, are meaningful in understanding just how broad the public use requirement has become? Or do they all merely suggest that the court is clinging to a case-by-case fact determinate analysis, essentially throwing up its hands and avoiding the thornier question involved in setting a clear and universal set of factors to determine acceptable public use justification for a taking resulting in private benefits?
It does seem to me that they are clinging on to a case-by-case determinant analysis, and you see variety of facts in both those cases. And I would have been very curious to see in the Eychaner case if more property owners had been impacted rather than just the one parcel of land, if that would have led the court to be more willing to hear it, making it a closer factual scenario to Kelo, and whether they would be willing to set universal factors or a bright line test. It's really difficult to kind of make these all come to a similar issue because they all have these nuances to them. Further, there is a really strong necessity to have some factors or universal test, and there needs to be, as I mentioned in my presentation, just more clarity on the remaining limits, and these limits continue to be blurred as different cases and different factual scenarios come forward. I think there's a new layout with the court having added 2 justices since the denial of cert in this case. If there would be a more willingness to pick up this issue, and I really hope that happens.